Welcome to SpringLaw's SpringForward Legal Updates webinar series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. SpringLaw is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit us at springlaw.ca. And now to our presenters.
Good morning, everyone. Hopefully no one's having internet issues this morning. We heard that's been happening, so hopefully everyone's having an easy tech morning today. But we'll jump right in and get started because we do have some formalities at the beginning, some admin stuff to cover before we jump into this great topic. So today we're discussing employment contract essentials for HR business partners, key clauses, compliance, and enforceability. And I am joined today by my colleague Marnie. We are both employment, labor, and contracts lawyers here at SpringLaw, and we're both going to chat today about this topic. So before we begin, we'd like to start with the land acknowledgement. So we acknowledge that the land on which we operate is the traditional territory of the Anishinaabe, the Haudenosaunee, the Huron-Wendat, and the Mississaugas of the Credit First Nation, who have stewarded these lands for generations. We recognize that Indigenous peoples lived and thrived here long before the arrival of settlers, and we acknowledge the lasting impacts of colonialism. As part of our commitment to truth and reconciliation, we strive to learn, unlearn, and understand the history and effects of these wrongs. We are grateful to live and work on this land. Now, today is all about legal information, not legal advice. That's a key distinction that we need to draw. So, we're lawyers, so no talk is complete without some sort of disclaimer here. So, we're striving today to give you great legal information, but if you have a specific legal issue, we can't provide legal advice unless you come speak with us directly. So this is just to provide you with some hopefully useful information. Here's our longer disclaimer that you can read at your leisure. I won't do that today. And I'll hand it over to Marnie to give us a little bit of a roadmap of what we'll be talking about today.
Thank you, Lexa. Welcome, everyone. By way of a few introductory comments, I'd like to first start with why are we talking about this topic? Most people don't wake up in the morning and think, I want to talk about legal compliance and contract clauses. And Lexa and I don't usually either, although we do like to do this contract drafting probably more than most people. But why is this topic so important? We know it's important because we spend, several times a week, we spend time with our employer clients talking about these employment contract and policy updating exercises. They're really their projects, and it's great to have such a long list of attendees, and we can cover this information that, again, we talk about so often with our clients. And we find that most HR professionals or anyone wearing that hat in their role in their organization, they know that there's some employee-friendly case law out there in Ontario, but they don't necessarily know what it means or what they should do about it. So we're hopefully by the end of this session, you'll be very clear on that and whether you need to take action and how to go about doing that. So I think at high level, we all know that up-to-date and enforceable contracts are important because they create certainty for both employers and employees. They save a lot of hassle, both in preparing for termination and afterwards. And they reduce employer costs. They reduce employee costs as well in terms of not needing to seek legal advice because they know what they've negotiated or what they accepted on at the beginning. So they reduce costs in a couple of ways. And we'll discuss how in more detail these updating exercises helps with those three positives that I've just gone through. And so with those of you, for those of you who are wearing the HR hat and you're true business partners, this is a critical a topic because it really will, it's a starting point for anyone starting in that role in a new organization or if you've been there for some time and realize that you need to dust off the contracts, it's as an HR business partner, it would be you'd be remiss in not dealing with this, because we see regularly how much it can cost employers if these things fall out of date. Really, quite literally, 3 words can make a big difference in a contract and lead to a whole bunch of time and effort and costs. So our goal is always to help our HR clients succeed in the role, and all the things I just said help an HR professional succeed in their role and reduce costs on different levels, and generally sleep better at night. And we know that terminations are one of the most stressful things for anyone wearing an HR hat. I know that from my years of working with HR professionals, and it never gets a whole lot easier. So the terminating, I talk a little bit about terminations, and at least if you could take me to the next slide, Lexa. In terms of terminations, obviously they're this very common function for HR, those in HR, and we want the process to be smoother for you when you need to do it. So there are a couple of types, as you know. There are individual terminations, a one-off, might be performance-related, other reasons, business reasons. It doesn't matter. It's one termination, or you might have a reduction in force with a whole group of folks, which is a much more involved process. Either way, the starting point is always the employment contract, hopefully the signed version of the contract, and it all starts there. So you want, as an HR business partner, HR professional, you want to have an up-to-date contract, signed contract, and you either are experienced and you feel you don't need legal advice because the terms are clear, or that's what you send to your employment counsel to help with a smooth exit process. So the goal is to have that certainty when you're starting with the employment contract on exit at the end of the employment relationship, and really you want to eliminate what is usually a costly debate or that evolves into a negotiation about an employee's common law reasonable notice entitlements. And many of you will know that that is not an exact science. It's based on factors that come out of a case called Bardall Globe and Mail from many, many, many years ago. And those factors are looked at by both sides, and they decide whether what the appropriate notice period should be. And this can lead to legal fees by both sides and lots of argument about essentially how long it's going to take that person to reemploy, and therefore that's the reasonable notice period. So pretty nebulous concept, and there's not much certainty there. So that's why having terms nailed down at the front end of the contract is better for both sides. So moving on, we're going to give you more tools about how to get to that place of certainty.
Yeah, absolutely. So, Marnie was talking about the certainty we're looking for with the termination clause, but an employment contract audit and, hopefully also looking at your policies, handbooks, all of the sort of ancillary documents that are tied to the employment contract, which we'll talk about a bit more later. But employment contract audits can lead to productive compliance cleanup as well. So not just, we're not looking at just this one clause, the termination clause. We're, looking at everything holistically, and some other compliance issues can be spotted in these audits that can proactively address some issues you may have in your workplace, and ultimately save you a lot of headache and money down the line. So, we may look at your contracts or your policies and find that the workplace has been miscalculating overtime, using an incorrect overtime threshold, things like that. If overtime is not handled in a compliant manner, this can really increase, there can be significant liability if practices aren't addressed, especially with large workforces. And the same goes with vacation. So how vacation is being calculated, whether it's being paid out correctly, paying it on all wages. That's something we see really often, not paying vacation pay on commissions or non-discretionary bonuses. So that's a really large area of potential liability and even potential class action lawsuits, depending on the scope of it. So, that's not to scare you, but it is to say that looking at things proactively and not only reactively can save a lot of headache down the line. And those are all things we would be looking at in any fulsome audit of your employment contracts. So, and then there's, some less urgent things as well that we could see, and then you can go back to your team, look at the budget, decide what to deal with and when. But, there may be things that don't need to be addressed right now that may not create, huge liability, but we may want to change that practice moving forward. So really there's only upside to looking at these employment contracts, making sure everything's compliant with the applicable employment standards legislation. So that big word, compliance, that's going to come up a lot today. So I know case law isn't anyone's favorite topic other than a few legal nerds, some of whom we work with, but so there have been some recent cases, Waxdale, Dufault, Henderson, and these have, in the last 5-6 years, have really changed the landscape, specifically in Ontario, about employment contracts and specifically termination clauses. So just high level, these cases have confirmed that enforceability depends on the contract as a whole. So not just looking at the termination clause itself. If we're dealing with a wrongful dismissal termination case, we're not only looking at the termination clause, we're looking at the contract as a whole to make sure that it's enforceable. Courts will invalidate termination clauses due to ESA non-compliance, vague or silent language, and concerns over clarity, ambiguity, and the inequality of bargaining power that is between employees and employers. So some of this case law is quite recent. Most recently was Dufault, I believe. So if you haven't had your contracts reviewed in the last 12 or 18 months, it's important to do so, because Dufault, I believe, was February or March last year, and that was a pretty significant change to what we look at when we're reviewing employment contracts. So it is important to have it happen pretty regularly. So as I said, remember to have a look at the whole contract. Some areas that we often see issues may be the probation clause, the resignation clause. Any errors in those provisions could invalidate your termination clause as well. So it is really important to have a look at everything as a whole. And then a lot of our clients are interprovincial employers. So especially with the rise of remote work, virtual work, there's lots of clients we have who have employees all over the country. And so it can be a challenge to draft compliant employment contracts when you're trying to be compliant with all of the provinces. So, we generally, our approach is to create one template, but to have it be flexible, use the language of employment standards legislation, and the bones of it will stay the same for each province, and then keeping in mind the subtle but very important differences between each province can make things a little bit more straightforward. Most employers like to have consistency amongst all their employees whenever possible. So we will review and let you know what variations there are between each province and go from there, but trying to keep as limited number of templates floating around as possible can make things operationally, administratively a lot easier for HR folks. And if it's an employee in Manitoba, you have highlighted, Manitoba, insert this language regarding X, and otherwise everything's the same, and that just keeps things moving smoothly, and you're not rifling through all the different contracts for every province. So that ensures the contract clauses are compliant with all the applicable employment standards legislations in which the business operates.
Lexa,
of course.
Some employers, HR folks, like to have more detail set out, and they come to us, with templates or proposed language that they want to go in the contract to be inserted into the contract. And as Lexa said, we tend to prefer a less is more approach, because less language means less potential ambiguity. And so, a nice tight contract that's very clear to anyone reading it, don't have to be a lawyer, that kind of thing is our end goal. But if you as HR want more details set out, for example, how, vacation accrues and is, what the entitlements are in detail, we talk about that, and we can put it in policies or an employee handbook or a handbook that might have different sections for different provinces. And it depends on the goal of the employer and how much detail you want. So, because I know that some HR folks want it as a guide, an employee handbook. Everybody knows what's happening and how it's calculated. It cuts down on questions. So we deal with that typically in policies outside the contract. So I just wanted to add that not everything has to be really bare bones. Absolutely.
Absolutely. Yeah, so, what the courts are telling employers through these decisions, as I'm sure many of you have heard before, Canada and specifically Ontario are extremely employee friendly. The courts are extremely employee friendly, and that's the sort of lens we have to look at contracts through when we're reviewing them. So, any ambiguity, anything vague or unclear, if it's not clear whether it potentially could violate the employment standards legislation, it will be interpreted in the employee's favor, and it will be interpreted against the employer. So as Marnie was just saying, we want to make sure everything's in clear language. Is it clear to you? Not as a lawyer, but as a regular person, is it clear to you what's being said in the contract, what the employee's entitlements are? And that's why typically in the contract itself, we do advise that less is more, tight clauses, less, no unnecessary detail where possible, because anything that isn't 100% clear to a court will be interpreted against the employer. And that's where, more detail, obviously you want the specifics of processes and entitlements set out somewhere, and that, policies or handbooks, as Marnie said, it is a great place to do that. And it's also important to note, as we've been sort of referencing, that courts can scrutinize documents beyond the employment contract. These can be, imported into the contract by reference. So if you do reference certain policies, or those are a part of the, onboarding package, those can all be looked at, scrutinized by a court as well. So things like incentive compensation plans, confidentiality agreements, conflict of interest policies, anything specifically with termination related language, that's really where the red flags start to go up for us. So that anything, if you breach this confidentiality policy, your employment could be terminated for cause, something like that. That's a red flag for us, and we're going to take a look at that and see whether that language is necessary, whether it's a potential breach, and whether it's better to just remove that altogether. So that would all be a discussion we would have. And then, as we've already sort of talked about, annual reviews at least are necessary due to evolving law. This law is changing really rapidly, and we understand how frustrating it is to work with a moving target. We're working with a moving target as well. But when we do a contract review, we're looking at the current case law, and we're also aware of what the trends are and where things are moving, and we're doing our best to be as conservative as possible. And we can sort of see the writing on the wall in terms of where the courts are going, and we're doing our best to anticipate where the case law is headed. But the best way to ensure you're continuing, you have a compliant contract and it's still compliant, is to check in with your legal counsel at least annually. Put it in your calendar, make sure you're staying on the right side of any new case law. That's really the best way to be able to sleep well at night and feel secure in your employment contract.
And at the risk of this being a spoiler, Lexa is going to give some search terms that are going to come up in a few slides that can help you decide if you have a problem and how big the problem is. So stay tuned for that. Okay, so if you decide that this may be an issue and you want to figure out whether you need to do an employment contract and policy update, it's a two-step project, really. You're looking at your existing your template, your existing template for your new hires, so the candidates you interview, you make an offer, you send it out, and then there are your existing employees. So I'm going to talk about them in two very separate buckets because the approach is different. So starting with your new hires, this slide 14 can actually be, I probably should have called it a checklist. I think it's a good slide to refer to once you decide you're going to proceed and seek counsel and go through this exercise. So what you want to gather is some information about the workforce, an overview of the workforce. So provide a list of the number of employees that you have, the provinces in which they reside, and general organizational chart type information. I mean, if you have an org chart, that's always handy to receive, but just a breakdown of the leadership team, and then, if you have a sales force, how many there are, what provinces they're in, professional designations, software engineers, people like that. Just an overview so that we can assess, things like overtime entitlements, a number of employees in certain provinces trigger mandatory policies and things like that. So putting together sort of the anatomy of the workforce is very helpful for us to skim up front before a consultation. Then you're going to dig up your most recent employment contract template, and I say template or templates because you might have different versions for your salespeople and for your engineers and for your leadership team, your executives, and we would look at whether that's necessary and whether you could combine certain ones and make it easier for HR when they're hiring, just to do a few tweaks and make it applicable and less of a chore upon hiring. So you may also have you'll have an indefinite term contract, which probably is your most common one. You'll have a fixed term contract, which we always like to see because there's so much risk that is carried with fixed term contracts. And we always want to have a conversation about when to use them, when not to use them, and how extremely important it is to have an updated termination provision in these contracts, because if it's out of date, you could end up as an employer having to pay out the entire remainder of fixed term contract if you try to end it early. So really huge potential risk with fixed term contracts. And I already talked about different versions for different roles. So dig those up, provide your snapshot of the workforce, and attach the templates with any specific, asks, wish lists around the contracts. You're also, it's helpful to know when the latest review was and by whom, and if it was done by an employment lawyer who's paying attention to the evolving case law in Ontario. That's helpful for us to know, just to tailor and do an efficient review, to have all this background information. Lexa's mentioned a few times ancillary documents. So anything referenced in the contract, any policy, even if it's bonus plan documents, we don't review those typically, although they should be provided to the employee because it's a part of their employment contract, that they should be provided in the onboarding process. But in terms of the legal review, we would like to see generally the conflict of interest policy, confidentiality policy, and so on, because it could have this termination related language buried in it. Now, we will have a conversation about, if you want a narrower scope of review and you feel that the ancillary documents have been reviewed recently and they're okay, or you want us to just focus on certain sections, we will give it an opinion on, that's probably fine in this case. Stock option plans are often, non-negotiable and they're not revised that often. We'll look at the key areas, that kind of thing. So we try to avoid ballooning the project. But just to know what documents there are, so we know we're dealing with at the beginning, is very helpful. So listing those, and then we decide what to provide and what we would review. Bonus and commission plan documents are important, and we do recommend reviewing the termination-related language. And those, a lot of employment litigation is centered around the terms in those plan documents. So those are worthwhile taking a look at. I mentioned stock option plans, policies, and attached schedules and appendices. Those fall in the bucket of, we give us a list and we can decide on what's worth the spend, what should be looked at. So that's your sort of checklist for your new hire template to review. So let's take a look at the existing employee situation. Once we've done an update for the new hires, typically the process is we've got the new fancy shiny updated contract, and then we have a conversation about what does it look like for your existing employees, and do we need to take this new hire fancy new updated template and turn it into what we typically we title it amended employment contract. and we use those updated terms, and we talk about rolling that out for existing employees. So this requires a more strategic analysis. You're going to have to look, we'll take a look at what the entitlements on termination are, whether the clauses are out of date, and if they are out of date, what's the potential liability? So do you have, are they entitled to common law notice? And if they are, what is the range of potential costs? Is this a younger workforce, not long service, likely to reemploy fairly quickly, or are we dealing with longer service employees who have significant common law entitlements? That's part of the initial analysis. We have a worksheet that we use so that we can be efficient about looking at, again, like having a snapshot of what the existing employees have in terms of contracts and what their entitlements are. And then we do our strategic review of the impacted employees. And sometimes we decide that, not doing nothing is best, and rolling out a new contract for certain employees is not advisable. It's going to impact morale. You've got a valued workforce that you don't want to take these steps and upset things, and it's very much at the forefront of our conversation. These strategic reviews about what to do and what not to do, and if you roll out updated contracts, what would make it attractive for the employee. So we look at available consideration, which is the fancy legal word for something of value that the employee has to receive in exchange for accepting new terms of employment, which in this case we're talking about updated termination provisions. So consideration could be a pay increase, but it should be a pay increase that they weren't going to receive anyway annually, because that is likely to be viewed as not sufficient valid consideration because they were going to get it anyway. So we would talk about a signing bonus or any other kind of perk that would be of value to the employee. Sometimes we also discuss providing notice of the changes. So for example, if we speak with a client in September and decide that the contracts need to be updated, and there maybe are a few other policies that should be updated, we would talk about potentially a January rollout of a new contract when salary increases would be happening, maybe provide a signing bonus, and let them know in September that based on changing law in Ontario, we're going to do an updated employment contract rollout, and you'll be offered amended employment contracts in January, for example. So you get a few months of notice. You might offer a signing bonus and alongside the pay increase. And this would all be documented in the amended employment contract, and you're very likely to have an enforceable contract at that point, assuming that you've given the employee, you've been transparent, you've given them time to review the new amended terms with a lawyer, and you've been transparent about the process. That is how, and in strong communication with them so they understand the purpose, that's how a successful rollout of updated contracts can happen, and you don't have employees thinking that there's something sinister going on behind the scenes and they're losing entitlements. And you give them time to ask the questions that they want to ask. And some will negotiate better entitlements on termination, and then that's a negotiation conversation that the employer has with the employee. And so again, I mentioned sometimes if you decide the potential liability is too great or it might upset your valued workforce, you might decide just pause and do nothing and plan ahead and figure out a better time to roll this out and put it in the calendar and look at it at a future time to do this cleanup of potential liabilities that are there. If there are no terminations planned, you might decide to shelve it, come back to it in 6 months or a year, but it's important to know what the common law entitlements are and what's kind of potentially lurking there for business planning purposes. If you do roll out employment contracts, updated employment contracts for employees, remind them to keep the signed versions of their contracts, because we had a scenario with, oddly, a couple of employees following a group termination where they sought counsel to find out if what they were offered was in line with their contracts, and they didn't have the updated terms. So they incurred legal fees. The employer incurred legal fees to review what the entitlements were, and it wasn't a significant lift on our end because we provided the updated signed contracts which the employees didn't realize were now the enforceable contract. So keep that. Those are the new terms. They just got confused, and we went down a path unnecessarily. So make sure that they file their new contracts and they understand that those are the new terms of employment. Okay, over to you, Lexa. This is the much anticipated slide I was referring to, where you can do your Control F with these terms.
Yeah, absolutely. So as we've talked about, already a few times today is, we're not just looking at employment contracts, we also want to look at the policies as well, and review to ensure there's no ESA breaches buried within them, or, as we mentioned already, confidentiality or conflict of interest policies. So one of the easiest ways to start this process is to just, as Marnie said, Control F for your initial diagnostic in contracts and policies to see, just where things are at. So the words like for cause, with cause, immediate termination, without notice, without pay, for any reason, at any time, or sole discretion, those are all sort of red flag terms that we would definitely want to dive deeper into and most likely remove and figure out how to rework those areas. Something else worth noting is something called a savings provision. So that would be something like, you can be terminated for cause at any time for any reason without pay or notice, subject to the requirements of the Employment Standards Act. That second part, so the first part is non-compliant. The second part is trying to save it. And the courts have found that subject to very limited circumstances, a savings provision does not save anything. So just because you've said with good intentions, subject to the Employment Standards Act, will comply with the Employment Standards Act, that doesn't cut it according to the courts. And that's why we like the language to be really tight, really clear, saying exactly what, will happen on termination, what employees will get without any of that sort of legalese of saying one thing and then trying to save it with something else, right? So savings provisions are something else that we would definitely look out for during that review.
Okay, so the good news is we're going to get probably some time back in our calendars because this is a shorter presentation than what we planned for. But we have a lot of questions coming in. We're told by our team we have about 100 attendees, so we're going to field some questions. But before we do that, here's a wrap-up slide of the employment contract compliance assessment and the things that we've touched on all these issues. But what you're going to want to do is review the content and drafting history of your documents, employment contracts and policies. And again, it's a two-step process. So you got your new hire template and your existing employment contracts. So your priorities will drive what you need first. If you're about to hire somebody, obviously that's going to be the priority. The existing employment contracts is usually less of an immediate concern. It's more of a planning thing to understand what the potential costs are should you need to move to termination. And by the way, I didn't say earlier that typically doing that as a group is, again, with clear communication, works better than on a piecemeal basis because employees wonder why it's happening, and you need to explain that it's related to new case law in Ontario, and that it's a rollout for all employees, so that the employees don't feel singled out or wonder why they're being offered something that others aren't. It's a confidential process, and they are asked not to discuss terms of employment with their colleagues, but everybody can know that this is an update and a rollout that's just a workforce-wide. So again, it's involves reviewing the policies, plan documents, and contracts with termination-related language. So we've tried to be clear about, don't just go to the termination heading in the contract and look only at that, or just send us that, because these problems can be buried in various documents and even various parts of the employment contract. So it's termination related language. Another term, actually a search term that we should add to that list, Lexa, is termination, because then you can you see what's happening around that, around any termination related language. Starting with that, we have immediate termination listed, but termination on its own is a good Control F term as well. And again, this Waxdale is the case that started all this, Waxdale and the cases that follow it. The purpose of a Waxdale review, as we call them, is to look for potential employment standards legislation breaches. So we're looking at, when we look at those search terms, we're looking at, is there anything in here that potentially breaches the Ontario ESA? And frankly, it's the same exercise in other provinces. You always want to be ESL compliant in any province. That's the purpose of this exercise. Search terms on slide 17 we've referenced a few times, so I would flag those, do a cut and paste and keep them handy. And then you're reviewing your number of employees with outdated contracts and reporting to your leadership team on the potential issues once you've done that analysis, and we certainly help with that cost assessment once you've identified which ones have these Waxdale problems. And we do this, help with a strategic review and analysis about whether, when, and how to roll out updated contracts. Again, communication plan, timing, what's the consideration going to be that you're providing in return? That requires planning, because it's got to be, the employer's got a budget for that depending on the number of employees. They've got to figure out what's appropriate for the workforce. Are you going to provide some notice, advance notice? So that one is worth looking at sooner than later, but it may not, the rollout might not happen for several months. And so that, and again, you might do nothing. You might choose to do nothing, but it's important to know what the status is and what the potential risks are, so you can report that to your leadership team. Now, a couple takeaways, and then we'll look at some questions. So we hope that we've learned today can help you go back to your leadership team and say, look, this is a project that we learned about that's especially important in Ontario, driven by a case called Waxdale. We provide budgets, legal, an estimate, and what's required based on the information we receive back. But you can take that to your leadership team and say, this is why it's important. These are the potential issues we have. And really, it's an insurance policy, essentially. You're trying to protect against unpredictable termination costs for your workforce. So hopefully you'll understand after this session why the planning for that strategically is so important, because it reduces costs and creates predictability for both sides. So that's how you can frame it to your leadership team as an action item. And when we've seen this now post-Waxdale several times, we help our employers update their contracts, and then they come to us with, unfortunately, business is such that we have to terminate a group. Can you help us do that? And, again, it's seamless. The HR folks sleep better at night. This horrible part of their job is easier because the contracts are clear and the employees understand what they signed, and therefore, the termination letter mirrors the employment contract. And we've seen this several times where it's a fairly seamless process with some administrative questions potentially, but it's clear and you have that certainty. And so I always say, when we go through that exercise, report back to your leadership team that the updating exercise we did a year ago or 2 years ago or 6 months ago is the reason why this is all finished and everybody signed off, and you're moving on and focusing on other things on your plate, and the business is not dealing with demand letters from employee side counsel or wrongful dismissal litigation. So we're seeing that, and it's a big it's a success for HR business partners, and it's an important thing to get ahead of, and your leadership team certainly would be very happy with that achievement. I can say from experience. Lexa, do you want to?
Yeah.
So, content.
Yeah. So as we've talked about, this landscape is changing pretty rapidly, and a single decision can really change your contracts and how watertight they are. So staying current with blogs and newsletters, we have both of those things. So signing up for our newsletters and checking in with blogs from us, as well as other employment law content that's can help you stay up to date, and then bookmarking key resources regarding ESA compliance. For instance, the Ontario ESA Policy and Interpretation Manual. I know in our firm we all use this pretty regularly. No one can have every single detailed rule memorized. At least I know that I don't. So having that at your fingertips to look that up and confirm to ensure, again, that big word for today, compliance, can be really, really helpful. So those are some recommendations. And then we've got a bunch of questions in the chat, so thank you all for those. So I'll start with, is your recommendation to reference the employee guide in the contracts for details on vacation accrual, etc.? So yeah, so if you have, let's say, an employee handbook or something like that, you can say, vacation, for more information on vacation, see the employee handbook and reference it that way, or referencing specific policies or things like that within the contract itself, but then you don't end up with a 50-page contract with every single rule imaginable. You can really keep the contract, as we said, as tight as possible, and then have the more detailed handbook or policies live somewhere else, but you can reference it in the contract just so it's all super clear.
Let's add to that too. Some employers, especially small ones, want a really simple employee manual as well, and they'll be very basic in the manual and say your vacation entitlements will be administered in accordance with the applicable provincial employment standards legislation. So in Ontario, it means you start with 10 days vacation, and after 5 years, you go to 15, and you might go into that level of detail, but otherwise, if there's an issue, you have any questions, we'll pull up that handy link and we'll take a look at it. And if we can't figure it out, we might ask our employment lawyer, but all of that information doesn't necessarily live in an employee handbook. So that's another pretty simple way to have a very basic handbook. So you don't have to go into all this detail. And some HR professionals build it as they go based on the issues that are asked by their workforce. So there's varying levels of detail for employee manuals and policies too.
Yeah, absolutely. Marnie, I'll address this question to you. Should we make an offer letter for promotions or other job changes?
Yeah, I hate to say it depends, but it does. It depends on the level of changes that are happening, but most often I'm always looking for the simplest approach, and you want to document everything in writing. So what is the simplest approach to do that, and where is it going to live, so that if HR changes, how do we know what's enforceable and what the agreed upon terms are? So for promotions or job changes, I would typically do a one-page amendment and have them sign it and reference all other terms. So your promotion is effective this date, and your pay increase is this, effective this date. All other terms of your employment contract which you signed on this date remain in force, which is very important. So we are capturing in the termination clause that's up to date with that one pager. I would say that's a best practice. But if you sent an email and said, congratulations, effective this date, your promotion is this and your salary is that, you'd probably be fine too. But I would always recommend that you reference the enforceability of the earlier terms of the contract. But it doesn't have to be fancy. It has to be in writing somewhere. And so an email where they confirm receipt is fine, but if we're asked to, I just do a simple one-page amendment that gets put in the employee file that cross-references the original contract. Awesome.
Here's one that says, if someone changes jobs internally, can we still use a probation period? No. So the probationary period under the employment standards legislation in Ontario, it's 3 months. So it doesn't matter which role the employee has been in. If they've been with your organization, after 3 months, you have to provide them with notice of their termination under the Employment Standards Act. And that's, looking at their job, their time at the employer altogether, not in each specific role. If you put someone into a new role and you want to have, for your own internal review purposes, if you have, increased reviews during the probationary period or something like that, and that's something that you want to institute when someone has a new role, you can do that, but their termination entitlements will not change if they're being moved somewhere else internally. So that's a good question. This one's a quick one. Our contracts are issued electronically. Is that still okay to have an electronic signature? Yeah, that's fine. That's the way of the world these days. Here, Marnie, I'll put this one to you. Would a job promotion alongside an increase related to the promotion justify having an existing employee sign a new contract that has updated clauses and policies?
Yes, unequivocally yes. So that's the perfect scenario where promotion, new role, raise, here's your fresh terms of employment. Here are your fresh terms of employment, take it away, review it, sign it back. So that is not going to be open to challenge. It's where you're relying on a pay increase where the employee might say, but I've had this pay increase, it's essentially a cost of living increase, and I've had it for the last 6 years, and now you're giving me new terms of employment. That's likely to be a good chance of it being challenged successfully on termination if there's a dispute around it. And so that's where we talk about, we recommend signing bonus and other ways to make sure that consideration is of value and going to be valid. But yes, this is promotion and raise is that's when we talk about planning ahead. That's when you think about events that are coming up where you can offer new terms of employment, updated terms of employment in exchange for something that the employee is going to be happy to be receiving. And again, if with the promotion, they decide they want to negotiate a specific termination provision, this session isn't all about capping everybody at employment standards minimums. It's about creating certainty. So if an employee, usually ones with more leverage and bargaining power, comes back and says, in my last role I had this in my termination provision, or I understand this is more appropriate for my level of employee, I'd like to propose that. There's a negotiation at the front end, and still we have that certainty on exit, and both parties know what the deal was, and the termination letter reflects the deal, and people walk away without this dispute over what common law notice is appropriate.
Yeah, absolutely. Here's a really good question. So if it's recommended that we not use terms such as just cause or with cause, what would you suggest be used instead? So that's a really great question. So our approach generally now, in the wake of some of these more recent cases, is to not have a section about just cause at all, because it's so scrutinized and it's so difficult to get it right, and the courts are changing. Again, it's a moving target all the time, and whether you have a just cause provision or not, it doesn't change your ability as an employer if there's an appropriate situation to terminate for just cause, which are few and far between, and we have whole webinars on that. But if it was a situation that amounted to just cause, it doesn't matter if you have a provision or not, you have the legal right to do that. So there isn't really a ton of benefit in having a with cause termination provision in your contract, and it actually, the way we see it is it just generally opens up more risk without a lot of upside. So it can usually just be removed. I'm sure there's scenarios that are different, but that would be our overarching approach.
That was a good answer to a complicated issue. Yeah, it's a tricky one. And that's where I would say, at SpringLaw, we do favor a DIY approach wherever possible, but this is worth the spend. It's worth the investment. We weekly talk about clauses and language, and we pop things in a termination provision chat regularly, and we collaborate on, how bad is this one? Is this a 6 out of 10? Is it a 7 out of 10? What would a court say about this one, and why? And often we don't always agree on, how flawed the clause is. It's an analysis based on, the most recent case law. So I would say it's well worth having a legal review rather than just stripping out certain things. The search terms that we gave you, or that we said are non-exhaustive, that's just to flag potential issues, but we're not suggesting you go delete them and draft the clause, because we don't always agree internally on how a clause should be drafted. We needed all 8 lawyers to decide where we were going to land on what's appropriate for, there are different types of contracts. So.
Yeah, absolutely. I'll put this one to you, Marnie. Can you have a fail-safe provision in the employment contract to reflect the cautious approach and ensure minimum ESA is provided and does not make the employment contract unenforceable?
So the fail-safe provision, that sounds like I'm interpreting that as a savings provision. Maybe let me know, Lex, if you see that differently. But a savings provision, we always put that in our contracts. I think our heading, our bolded heading is Employment Standards Legislation Compliance or Employment Standards Act Compliance. And then we say, in any case, if ever this contract falls below the employment standards, you will receive your minimums in every case type of language, which is a nice reassuring statement for an employee to read, and we do have that in there. But if there's a flaw in the termination related language anywhere, it will not be saved by that clause. So while it sounds nice and it's helpful for things like vacation and overtime, and it's just a reassurance that, like, if we get it wrong around some of these things, we'll fix it and so on. But it won't help a termination clause that is flawed. The court would strike it out, and then you're in common law land with your employee, which is typically a more expensive prospect on termination. So the short answer is no, not for termination language.
Okay. So this one, I think, Marnie, you sort of referenced this already, but they've said, I know we chatted about termination clauses. Curious to hear your thoughts on severance clauses, specifically for executives. So I think that refers to, something above the ESA. So this has become a sticking point in contract negotiations. So I'm curious to hear your perspective on how much to flex on this above and beyond the ESA minimums. Mm-hmm. So, Marnie, you spoke to that already. Do you want to? Sure.
Yeah, this is, part business decision, it depends on the needs of the employer, the strength of the candidate, how much leverage do they have, what is the market, things like that. So that's the business part of the decision. And then where we come in, we often say, who's the candidate and what's the need, and tell us about the person and what is the market and do you have options. And then where we come in is we look at their level of seniority and their compensation and just sort of who they are in the world executive-wise and what space are they in. And sometimes I'll look at the case. We'll look at the case law. We have an excellent AI legal research tool that pulls case law for similarly situated individuals. And that's typically used on termination. It can be handy at the front end to see what a court would award this person and what their common law notice period would be if they were to litigate. So, and I might say give a range of 12 to 15 months if they're a very senior person earning very high compensation package. So we would say to the employer, this is the range of common law if they were to litigate and go all the way to trial. So, in terms of a negotiation, here's a starting point that would probably be attractive to the employee. This is within your budget. Why don't you offer, something in this range? And maybe it's 8 to 9 months, or maybe it's a termination provision that starts at a certain number and goes up with each completed year of service. Maybe it's capped at 12 months. Maybe it's capped at 6 months. So there's all kinds of creative ways that we make recommendations to get the candidate to a deal, an employment contract signed with a termination provision that they feel they're happy with, is enough insurance to them on termination. So that's a more involved exercise, and it's a worthwhile one for executives. It's not simple. And often executives will come with their own view, though they usually have their own legal advice. They might have a termination provision they've negotiated in the past, and they come with that expectation. This is, I'm coming from a role where I have this. This is what I'd like to see in the new contract. And that's part of the discussion, and they'll often make very, very valid arguments to support quite a lot of job security in a termination provision. So we help with that quite often. That's really effectively a business decision, and we weigh in on the legal components.
Perfect. So this one says, if we have employees on some older language contracts that could have red flags, can we ask them to sign a new updated letter or contract? And the answer is yes, but that's where that consideration piece that Marnie has been speaking about comes in. So if an existing employee already has an employment contract, in order for the new contract to be enforceable and valid, they need to be provided something new of value in exchange for signing that. So as we were talking about, if there's already, a promotion in the works or a pay raise that isn't, just a standard cost of living raise that they get every year, a signing bonus, something like that, an extra thing of value that the employee didn't have before has to be provided in exchange for signing the new contract. But they can absolutely be provided with updated contracts as long as that consideration piece is provided, and that's an area we see a lot of issues. Employers say, oh, we got all our employees to sign updated contracts, and nothing new was given to them in return, so that new contract that you probably spent a good amount of money on with legal review and things like that is useless, essentially. So it has to not only be a good compliant contract, but if they're existing employees, they need to have been provided with something new in exchange. So that's really, really important, and it's great to include that right in the contract itself. In exchange for signing this contract, you will be provided with a signing bonus of X, a raise of Y. So it's really clearly documented that if there's ever any reason to challenge it down the line, it's right there in the contract itself. So that's a great question. There was one I thought I would ask you, Marnie. With a new employment agreement when being promoted, do we need to advise the employee that the termination clause or other clauses have been updated?
I knew you were going to throw that one at me.
I wanted to hear what you had to say about that one, because that's a tricky one.
Yeah, it's a good question. I mean, I always recommend to employers to be transparent and communicative, and this isn't some sinister operation where we're trying to rip employees off. I mean, we represent lots of employees, and the goal here, as we've said, is certainty and to come to a deal that the both sides understand and accept. Appreciate that that's not always realistic because there is a power imbalance, but when we're advising employers, and especially with these rollouts, it's give them the agreement, let them know about the updates, that it's happening because of updated case law in Ontario. Take the time you need to review it, and I usually don't recommend calling out each amendment in the contract. You explain the updates, you give it to them, you give them as much time as they need. No rushing anybody, because that can come back to bite the employer, where employees say, I didn't understand, they gave it to me, they wanted me to sign it 2 days later. Not a good plan. You got to give enough runway for them to get legal advice and ask questions if they want to. Now, I will say, when you do your existing employee review analysis of what the contracts look like, if employees have already signed a contract that capped them at Employment Standards Act minimums when they started, this updating exercise is just confirming what they thought they were getting when they started and they signed the first contract. So I've almost always, it's been a very clean rollout. Employees, they're with this candid, transparent communication and valid consideration, they sign off and everybody moves on. Where it can be tricky is that the example I talked about earlier, we might have a very long-term employee who might take a long time to reemploy and is entitled to common law notice. I would have a specific conversation with the employer about how to handle that, and I probably would recommend, walking through, like, this is what we're offering, and this is why, and this is what we're prepared to do in exchange, and maybe it's a longer notice period before the termination provision kicks in, and maybe it's that you say, look, this is a business decision we're making because we need to try to manage our termination costs, and here's what we're going to do. So that giving them notice of when the new employment contract kicks in theory, the purpose of notice is if they want to look for another job, they've got a long runway to do that. If they don't want to accept the new termination provision that limits them to something less than their 24 months that they're entitled to because they're a super long employee, then they have time to move on. So in those cases, this is where absolutely a strategic review with your employment counsel is important, so that you can do this in a way that's not going to impact employee morale, but you can still make your business decision, and then you pitch it to the employee in the way that is most suited to the circumstances. So there's a little bit of an it depends answer, and it does, because it depends on what they're giving up, and the communication should depend on that. So that's an important part of the analysis. Who's the person? What do they currently have? And what is the change that's going to happen when they sign the new contract? If you have an employee who is terminated whose employment is terminated without cause down the road, and they had no idea they were signing an amendment that was stripping them of their 12 months of common law notice, then there's a very good chance they're going to be able to challenge the enforceability of the contract. So you want to roll it out in a way that, and this is what we help very carefully with the rollout and the communication, so that doesn't happen, and so that the new signed contract is enforceable. We have 48 seconds left.
Perfect. Yeah, so thank you all so much for the questions. That was really, everyone was very engaged and had really great questions, so thank you. Our next session is on June 18th at 10:30 a.m., same time, same place, and it's on AI and the future of work, so definitely a hot topic there. Feel free to follow up with us with any questions. All of the email addresses are there. You can visit our website, springlaw.ca, follow us on social media, or sign up for our newsletter to stay updated. Thank you all so much for being here. Thank you, Marnie, for being a wonderful co-presenter. And see you all next month.
Thanks, Lexa. Thank you, everyone. Have a great day.